Which I think we put the case on the desk. You go,
Yeah, is the file with that? Because I don't see the file. I looked at it last night. I just don't see it in here.
here. It was on your desk.
All right, let's pause here. That PSI they mentioned, it stands for pre-sentence investigation. Basically, a report that judges use to decide how much mercy or punishment someone deserves. It includes everything: background, mental health, prior arrests, even how sorry they seem. And if you think judges don't take it seriously, think again. That file can tip the entire sentence one way or the other.
All right. Earlier in this case, the defendant entered a plea of guilty to aggravated assault, a second-degree felony, and a pre-sentence report has been prepared. Have the parties had an opportunity to review it, and are there any corrections or changes to it?
Just, I've received and reviewed it, and we don't have any changes from it.
And state.
Same, Your Honor.
All right, it will be made part of the record for all purposes. And the agreement here is a cap of 10 years imprisonment. So we are looking at two options on the second-degree felony: no less than 2 nor more than 10 years confinement in prison. Also, the defendant could be placed on deferred.
Here's the deal: this is not just some slap on the situation. The judge is straight up laying out the two extremes: prison or probation, no middle ground. And notice how regular probation is not even on the table. That means the case is already serious enough to narrow the options. When a judge says that's not even legal here, yeah, you know it's real.
Or unadjudicated probation. I don't believe regular probation is an option under law because of the circumstances of this case. All right. Mr. Lewis, you may go forward.
Judge, this situation, fortunately, it wasn't worse than what it was. Definitely. But it was a situation where my client has been dealing with some harassment and bullying, dealing with the complainant, her friends, for a long time at this period. This confrontation here was pretty much her breaking point at that moment. It was totally out of character for her. Not something that, in normal, regular circumstances, she would have acted in that way in any way. It was a situation where, and when I say...
Okay, now things get intense. We are not just talking about name-calling or online beef. This is windows being shot out, actual harassment. It adds a whole new layer to this case. And you have to wonder, does that justify what she did? Or just explain it? And is the court going to care about the why or just the what?
Prior bullying and harassing information I'm talking about from people coming, breaking or shooting the windows at her home, to very severe or serious circumstances, and that these things have been going on, and actually have been even still dealing with some of it after this case happened, while she's been on bond, to the point of people associated with the complainant or either screen recording or whatever, sometimes docket, and would post these things on social media in an effort to taunt her while this case has been going on. And there was even a situation where she's had people try to confront her. Now, I will say my client and her actions since then, she's done everything she can on her end to try to avoid these situations at all costs. She had moved to a new location that is a safe place for her and her child. That's undisclosed as far as she knows, as far as people associated with the complainant. She haven't had any issues while she's on bond as far as attending court or doing anything of that nature, other than I believe she had one situation where when she was in the hospital having a child, she had to miss court, but they had medical issues at that time. She has a 4-month-old child this time to raise and take care of.
Now this is what judges actually look for in sentencing. Has the person tried to change school, new job, no new trouble, moved away from the Draymall signs of rehabilitation? But here's the kicker. Positive behavior after a crime does not erase what happened. The judge has to balance mercy with accountability. So ask yourself, if you were the judge, would you go easy on her?
As you see in the PSI, she has, until the pregnancy, maintained a stable work history, as well as going to school to help try to further her career. So she is making positive changes for herself, or I won't even say changes, staying on that same track. So I believe her future is one that's definitely salvageable in this circumstance. I think there's plenty of vehicles available through the probation department that could help Miss Money as far as move forward, as well as still be able to serve out any punishment or sentence that court deems necessary. There, I know there's restitution involved in this case that my client, through with her schooling and her career moving forward, I think she'll be able to take care of that and do what she can to make the plaintiff whole in that circumstance. There are other conditions, of course, that's available to the court, as well as county jail time or anything of that nature to satisfy any concern the court may have of her actually serving some time in jail is necessary.
This is where it gets legally tricky. Her lawyer is almost invoking self-defense, but not quite. Why? Because if there's not solid evidence to back it, it can backfire. Juries don't it by maybe I thought I was in danger unless it's backed by facts. And if she tried that at trial and failed, that's years locked up instead of a second chance.
And I know as far as her version of everything, she talks about, concerning the car running her over or running them over. If the evidence doesn't totally support that, but of course, what she may have been thinking of going through some of her friends at that time could have been it, but maybe not enough to rise to the self-defense claim that she could have maybe used that trial, liable to use that trial. So we are asking that the court seriously consider placing her on deferred adjudication. I think she's the type of candidate that will be able to make the most of that circumstance and be able to be successful and move forward. Also, she did want me to listen. She wanted the opportunity to address the court and let you know how she would, her plans for the future, as well as her being able to, how she feels for being able to be successful on deferred judge.
Yeah.
I just want to let the court know that I take full accountability of what happened today. And I am very, I changed my life all the way around. I don't hang around the same people. I have a child now.
Whoa, did you catch that? She says she acted out of fear, but the judge hits back. How were you in fear? That's the courtroom moment of truth. Judges want more than emotion, they want explanation. If her fear is not credible, it undercuts her whole plea for leniency. It's not just about what she feels, it's what the facts support.
I'm in school, everything around me is positive.
Did you have a child then on March 30th? You didn't have any, were you pregnant then?
I got pregnant after.
Yeah, okay. Go ahead.
And it was out in a hard situation, but I take full accountability for everything that happened that day. I wish everything was different.